Good afternoon. Welcome to the first seminar of our series on legal philosophy between state and transnationalism. When I say us, it's Osgoode Hall Law School, the Department of Philosophy at York University, and the funder of it all, the Nathanson Centre on Transnational Human Rights, Crime and Security. And today we're fortunate to have with us Professor David Lefkowitz from the University of Richmond, where he is a professor of philosophy as well as the founding director of the program in philosophy, politics, and economics, and law, as a PPEL, so it's an Oxford Plus kind of program. His research interests include the morality of obedience and disobedience to domestic and international law, the moral conduct of war, the nature of customary law, and the ethics and economics of climate change. So basically every buzz topic in moral, political, and legal theory nowadays. Professor Lefkowitz has published papers in numerous leading journals, including Ethics, Legal Theory, the Canadian Journal of Law and Jurisprudence, the Journal of Political Philosophy, as well as chapters in numerous collections, including the Philosophy of International Law, leading collection that was published, that was edited by Samantha Besson and John Tassiulis a few years ago. Today we'll present to us a paper entitled on a state's right to territorial jurisdiction. And we'll have a reply by Professor Dan Priel, who is a professor here at Osgoode Hall Law School and whom you all know. So without further ado, Professor Lefkowitz.
Okay. Well, let me begin by expressing my gratitude to the Nathanson Centre for the invitation, and then specifically to Francois for extending that invitation, also to Osgoode Hall and to York University, and perhaps most importantly to all of you for taking time from your busy schedules to come show me the errors of my way, or error of my ways. States assume, right? Sometimes they assert, but I think even more often they assume a right to rule. Right? And they assume a right to rule both people, their subjects, and also a right to rule places, their territory. Now, I've spent a number of years investigating what, if anything, could possibly justify the claim on the part of states to rule their subjects. Right? They assert it, as Joseph Raz suggests, perhaps necessarily they assert it, or the law asserts it. But be that as it may, I've been a proponent of what's come to be known as a natural duty or functionalist justification of law's authority, or of political authority. And the idea here is that the state is legitimate, and its commands, its laws have authority over its subjects, just in case the state meets certain conditions. And those conditions are specified, or they specify, the morally necessary function that a state plays. Right? I really don't want to delve right now into the details of that account, although I'm happy to talk about it later. But roughly the idea is that justice between people can be realized only via the functioning of a legal order. But not just any legal order, a legal order that meets certain conditions. So I typically refer to that as a liberal legal order, by which I mean one that respects certain basic individual rights. But I think there's also a condition that attaches to how the law is made. I'm going to use the placeholder democratic. Obviously, lots of dispute about exactly what that would amount to. But the upshot is that the law of a liberal democratic state is legitimate, and so has a claim to authority over its subjects in virtue of the necessary moral function that it plays. Right? So that's a story about the law's right to rule people. But recently I've begun to consider what, if anything, might justify the state's right to rule territory. And that's a distinct issue. It's not an issue that's received very much attention, certainly in contemporary debates, unlike the arguments about political authority or political obligation, which have received a lot of attention. But in the last few years, a number of political philosophers, legal philosophers, have begun to turn their attention to this question. And so, never one to be left out of a party, I've decided that I would follow along. And as I began to investigate the topic, I discovered that my preferred account of legitimate political authority over people seems to run into certain problems when it comes to giving an account of the state's right to rule over territory. Or rather, I should say, it seems to be consistent with, at least if not imply, an account of what justifies a state's right to rule over territory that I find problematic. Right. So let's see if I can work this. The problem is that a pure natural duty or functionalist account of legitimate authority of the state's right to rule can't account for two features of a right to rule territory which seem like plausible criteria for a satisfactory account of the state's right to rule territory. Now, like any criterion, you can always abandon it, but you can read these plausible criteria as kind of the price to be paid if we stick with a pure natural duty or functionalist justification. Those two criteria for a plausible account of a right to rule territory are particularity and persistence in the face of violation. So states claim or assume a right to rule not just some territory or other, but some particular territory. And so, at least as a starting point, if not a finishing point, but at least as a starting point, it seems we should look for an account that could justify that claim on behalf of states. Right? It seems to have a kind of intuitive plausibility to it. And relatedly, right, intuitively it seems that a state's right to rule a particular territory should persist at least for some time in the face of its violation. Right? So suppose that the United States, right, we get tired of those common trivia questions that say, what's the only part of Canada that is located south of part of the United States? And so we decide to forcibly annex Windsor, right? All that duck pin bowling and all that other great stuff I have there in Windsor, right? And we do it. Right? Now, on a pure natural duty or functionalist account, and the implausible assumption that the United States meets the criteria for legitimate political authority, but grant me that, right? Grant me that. On the pure natural duty account of legitimate rule over territory, as soon as the United States implements its legal order in Windsor, it immediately, right, acquires a right to rule that territory. So on this kind of account, there's no link between a state's right to rule territory and a particular territory. In fact, a state has a right to rule whatever territory it in fact rules. Right? In other words, the de jure right to rule territory follows from, without any addition, and immediately upon the exercise of de facto rule, legitimate rule, over the territory. And that strikes me as problematic. So I wanted to investigate some way of amending, right, or supplementing a pure natural duty or functionalist account of legitimate authority that would give me what I found to be a more plausible account of the basis for a state's right to rule territory. And my starting point in that investigation is a recent article by Annie Stills that was published in Ethics, I guess about a year and a half ago. Right? And Annie attempts to ground the justification for a state's right to rule territory in its individual subjects' rights of occupancy in that territory. Right? Okay. And so she says, right, the right of occupancy. Now, the right of occupancy is a right held by individuals. The right of occupancy is a claim to be in legal residence on that territory, to be physically present, and to have one's rights defined and enforced by whatever state has jurisdiction there. So for Annie, a state's right to territorial jurisdiction is going to follow from its individual subjects' rights of occupancy in that territory and several additional conditions that need to be met. So for instance, the state is going to have to be legitimate. Right? I'm not really going to worry about those other conditions. I'm just going to focus on this notion of occupancy because it's the idea of an individual right of occupancy that's going to tie the state to territory. And that's what we're looking for here, is a way of tying state to territory. Why I think there's a right of occupancy? What provides the moral basis for that putative right? Annie tells us that it is grounded in individual autonomy, which she understands here as the capacity to form and pursue a conception of the good. Now, on the plausible assumption that practically all conceptions of the good are going to involve pursuits, goals, relationships, and so on that have a territorial dimension. Right? So my conception of the good may have various relationships I have to my neighbors, right, to my coworkers, and so on, that are geographically located. Right? They have a territorial dimension to them. Right? So to the various projects I have, such as fixing up my house, which is, I'm discovering, a very expensive endeavor. Right? Obviously a territorial dimension here, right? That project of mine is located in a particular space. Right? On the plausible assumption that practically all, maybe not all, but practically all conceptions of the good are going to have this kind of territorial dimension, it follows that respect for individuals' autonomy, for their capacity to form and pursue a conception of the good, is going to require respect for their right of occupancy. Or so Stills tells us. All right. This is the formal statement of the occupation principle, right? The ground of an individual's right of occupancy, right? It sets out three conditions which are jointly sufficient to establish a right of occupancy. The first two I've kind of already referenced here, right? A person must be residing or have recently resided in the territory, right? His conception of the good, right? The integrity of the structure of his conception of the good, right, must be premised on stable legal residence in that territory. But there's an additional qualification that Stills adds here, and that's necessary condition number 3 up here, right? That the person's connection to that particular territory not be formed through a morally faulty act. And we'll come back to that. I think that that condition is a mistake. All right. There's a number of things that I find attractive about the occupation principle, right? Reasons that warrant further investigation of it. One I've already mentioned. It would allow me to reconcile my commitment with respect to a state's legitimate right to rule people with some plausible, I think, intuitions I have about states' right to rule territory. A second advantage is that it holds out hope of providing a rationale, a principled formulation of a kind of intuition, vague intuition that I have, which is that rights to territory do persist in the face of violation for some time, but not forever. Right? So that a right to territory can be superseded. Right? It can, which I'm not quite sure is the same thing, it can lapse. Right? So that if initially deprived of territory, right, a people or the individual members of that group, right, might continue to have claims to that territory for some time, claims to rectification, claims to return to that territory, for instance, but that at some point, at least for their descendants, and I'm going to argue perhaps even for them, right, that claim would lapse. Now, I have this vague intuition, but I would certainly welcome the ability to give some principled rationale for it that would spell out, with some precision at least, right, why it persists, right, how long it persists, and why it lapses. Then there's some general metaphysical gobbledygook about individuals and collectives that I'll spare you for now. But that's a third reason, right, a third kind of reason that I'm attracted to the occupation principle. All right, so let's characterize this, the occupation principle, so that we can see some of its implications. So at time t1, right, state A has a legitimate right to rule a territory if and only if, well, I should say only if, right, its subjects have rights of occupancy in that territory. But suppose at time t2, state B forcibly annexes that territory and expels from it all of those who had been rightfully residing there, rightfully occupying that territory, and replaces them with some of its own subjects. Right? For some time after this, though state B may exercise de facto rule over that territory, over territory T, it does not enjoy a right to rule that territory, according to the occupation principle. And the reason for that is that though people who are occupying territory T, though they are citizens or subjects of state B, have no right of occupancy in that territory. And in the meantime, those who are unjustly expelled from territory T, right, former citizens of state A, right, have a right of return to it. But suppose that state B fails to right the wrong that it has done. What then? Well, let's consider first a scenario in which all of the current residents of territory T, right, have been born there, right, subsequent to this forcible annexation by state B, right, and all of the people who were unjustly displaced from T have died. Right. In those circumstances, what can we say? Well, the first thing that we can say is that the current residents of territory T do enjoy rights of occupancy there. They reside there. I'm assuming that for the vast majority of them, at least, their life plans are premised on stable legal residence in territory T, and they are not morally at fault for having formed that connection to the territory. And insofar as they have a right of occupancy, rights of occupancy in Territory T, and suppose State B meets the other conditions that Stills sets out for territorial jurisdiction, then State B has a right to rule that territory. What about the descendants of those forcibly expelled from T? Well, here it depends. If they have established stable legal residence in the territory of some other state, then on Stills' telling of the occupation principle, they have no right of return. I'm misnamed here, right? But they have no right to establish legal residence in Territory T. However, Stills says, if they have not established, right, the descendants of the displaced, if they have not established stable legal residence in the territory of some other state, right, well then in that case, they do enjoy a right of return. Right? So that if they are stateless, in fact, she goes further, she says if they are subjects of an illegitimate state or if they are second-class citizens, right, then they retain a right to return to the territory in question. Right? All mistaken, I'm going to argue. Okay, so as I said, I think there's an initial attractiveness to the occupation principle, but I think that the principle is in need of clarification and correction, and that's really what I want to focus on today, although I will conclude my remarks with a few suggestions about the plausibility of the occupation principle in light of the revisions that I'm going to make. The first thing I think we need to get clear on is what is occupancy? Right? If we're going to talk about a right of occupancy, we need to know what it is that we're talking about that people have a right to. So if we were to be talking about a right to free speech or a right to freedom of religious practice, we want to be able to characterize what speech is. We'd want to be able to characterize what religious practice is. And so too, we're going to need to characterize what it is to occupy a territory. Right? And you can see here I've given you a couple of reasons, right, why we're going to need to do that. Right? If we're going to, for instance, just to talk about this third one, right, if we're going to be able to tell a story about the precise boundaries of the territory over which a state has a right to rule, and if the state's connection to territory is mediated via the connection of its individual subjects to that territory, well then there's going to have to be some story about, right, the boundaries of individuals' rights of occupancy, right, that then helps us settle the question of the boundaries of the territory that the state has a right to rule. Right. Okay. So what does it take to occupy a territory? Well, one thing I think is pretty clear is that it's going to take some kind of extended period of residence in that territory and the formation of a conception of the good premised on residence in that territory. But if we think about the kinds of examples I was giving you earlier about how a person's conception of the good is likely to have territorially grounded elements to it, then I think you'll see it's going to take more than mere residence in a territory. It's going to take the planning of a life, the arranging of a life according to social norms in that territory. So I think occupancy requires more than mere residence, right? More than merely being in a place. It requires the living of a life that is structured by norms of some kind in that place. But then the question is, well, what kind of norms are necessary? Still's answer is legal norms. In fact, she's not always so clear. Sometimes it's legal norms, and sometimes it's legal norms of a legitimate state. Right? But I think the stronger case to be made is for legal norms, not necessarily legitimate legal norms. Two questions then about this conception of occupancy. Right? What I referred to in the paper is the legal account of occupancy. Right? First of all, is this a circular definition of occupancy? So on the one hand, states get a right to do something. Right? States get a right to exercise jurisdiction over a particular territory because their subjects do something, namely occupy that territory. But the way in which their subjects occupy that territory on the legal account is by arranging their lives according to the legal norms that the state implements, right, in that territory. So there seems to be a kind of circular argument going on here. Right? We can't have occupancy defined in terms of jurisdiction, and then jurisdiction defined in terms of occupancy. But despite the appearances here, I don't think that there is a circular argument. Right? One person who recently has suggested that there is Avery Kohlers in an article that was published recently in the Canadian Journal of Philosophy. Right? I think the impression of circularity is the result of a kind of an implicit Lockean approach to this whole problem of connecting states to territory. Right? On that Lockean approach, there's a kind of two-stage process. Right? First, individuals do something. And I think the first is and perhaps as Locke tells us, right? First in time. So first people do something that connects them to the territory. And then they do something else that connects them to the state. But these things kind of happen in a progression. But I think if we leave that aside, if we don't think of occupancy as doing something to territory, right, adding value to it, however exactly we might cash that out. But if instead we think of occupancy as doing something in the territory, then I think we can avoid this concern about circularity. So I'm still working on how to formulate my response to this worry about circularity, but I'm beginning to think it goes something like this. Two things, really. The first is that the individual's right of occupancy and the state's right to territorial jurisdiction, right, emerge together. Right? So they come about not in stages, but rather together. So as the state, and this is the second point, as the state exercises jurisdiction, which initially it may not have any right to do, it simply does. But as it exercises jurisdiction, and then its subjects build their life plans on the basis of the state's exercise with that jurisdiction, the right to occupancy and the right to jurisdiction emerge. Right? So you can think of these rights then as emergent properties. Right? Initially we have merely facts, but from those facts at some point, or building perhaps, right, there's not a clear divide, we get certain normatively significant properties. All right. Second concern about the legal account of occupancy. Right? Well, does it really require stable legal residence in order to have a right of occupancy? And so I give you here just one example that might make us want to reconsider that claim. So suppose, I'm going to stipulate that what we have in the Horn of Africa is a severe failed state. Right? So that there's nothing like a modern state's domestic legal order. There's no centralized authority that is capable of creating, applying, and enforcing legal norms over all those who reside within the territory. Would we want to deny that the people living in that region have rights of occupancy there? Right? If we did, what we would be committed to is saying that their forcible removal from that territory does not wrong them per se. Now, of course, depending on how that removal is carried out, all sorts of wrongs and harms might be done to these people. But the mere fact that they were forcibly displaced from the region in which they had been residing would not count as a wrong done to them. But that seems crazy, right? Were we to do that, all else equal at least, were we to do that, it seems clear to me that we would do a wrong to these people. And apparently it seems clear to Stills as well, because she says in a footnote, right, that while these people, right, may not have certain rights to political self-determination and so on, we won't worry about that for now, they do have rights of occupancy. But of course, she just tells us that. She doesn't tell us why that is, and on its face at least, that seems at odds with her account of a right of occupancy as a claim to stable legal residence that's premised on the role that stable legal residence is playing in a person's formation and pursuit of the conception of the good. So what kind of arguments might we offer, right, on behalf of Still's claim, on behalf of the claim that I wish to make, that it would be wrong per se to displace these people? I think there are two ways to go here, maybe. There we go. One possibility would be to say that while it's true that there's no legal system of the sort that, as a good Kantian, Stills thinks ultimately we need in order to realize justice, nevertheless there are certain kinds of legal orders in place, and that those legal orders suffice to ground, right, stable legal residence of the sort that's needed to generate a right of occupancy. Right? And these legal orders, for instance, could be tribal legal orders, they could be religious legal orders. Right? That's one possibility. A second possibility would be to say it's not necessary that these people enjoy stable legal residence of any sort, as long as they live lives that are, to a significant degree, ordered according to social norms that govern their interactions with at least some, right, very vague term, but at least some of those with whom they interact on a regular basis. Right? One way to read these two possibilities is to say, look, at the end of the day, let's not get too hung up over what counts as law. For our purposes, that's not really going to be essential. What's going to be essential, however, still, on this account, is that a person's life is structured according to certain kinds of social norms. And as it happens, that is true for people living in Somalia, even in the worst times of conflict, and we hope that those are past, but in many parts of Somalia, not yet. Right? Even in the worst times of conflict, people's lives were still very much ordered according to social norms. Not nearly as stable as we might like, not nearly as determinate as we might like, right? But nevertheless, they were existent. Actually, one of the most fascinating facts here is that the Somali currency continues to be used, continues to have value. There hasn't been a Somali state in 20 plus years, but the Somali currency goes on. Right? Enough to make Friedrich Hayek dance in his grave. Okay.
Your government just recognized their government yesterday.
Yes, yes, their government, which controls about 10 square miles in Mogadishu. Right, right. So, those are a few remarks about occupancy. I'd love to get your feedback on those and any questions you have about them. But I want to turn now to some questions, some revisions really to various implications that Stills asserts follows from the occupation principle. I want to start with her remarks on the right of return. Right? So here again is Stills' claims about what the occupation principle implies for the descendants, or for either those who are displaced from a territory or their descendants. Right? Here, actually, we're focusing just on descendants. So if they remain a stateless people, reside in an illegitimate state, form a population of second-class citizens, right, then they have a right to be readmitted to the territory from which their forebears were unjustly displaced. I don't think that follows. In fact, I don't think any of that follows from the occupation principle if we understand it correctly. So let's start with those who are either legal citizens in an illegitimate state or second-class citizens. In fact, being a second-class citizen would just be one kind of legal status you could have in an illegitimate state. Right? I'm going to assume that on any plausible account of state legitimacy, there can be no second-class citizens. Right? So really, this is just if you're a legal citizen, you have stable legal residence in an illegitimate state. Well, it seems to me that billions of people right now, right, live lives that are premised on stable legal residence in illegitimate states. Right? They have rights of occupancy in the territories in which they reside right now, and I think we can cash out those rights of occupancy in terms of their enjoying stable legal residence in illegitimate states. As I intimated earlier, all of your neighbors to the south may qualify as such people. Right? So if the descendants of the displaced have established stable legal residence in another state, even if that other state is illegitimate, it seems to me that the rights of occupancy they have are now rights of occupancy in that state, not in the state from which their forebears were displaced. Right? And it's interesting, I have a quote buried in here somewhere. I think Stills is even dimly aware of this, because right after the remark I just quoted, she has a footnote in which she says, well, maybe it would be best for these descendants of the displaced who have been residing, right, and had legal residence in some other state all their lives, maybe it would be best for them if they were granted full citizenship in the states in which they now reside. But I think she's actually committed to something stronger. Not only that it would be best for them, but that they have a right to full and equal citizenship in the states in which they now reside, in which they have a right of occupancy now. And in virtue of meeting the conditions for occupancy in the state in which they now reside, and in which they've always resided, if we're talking about the descendants, they have no claim of occupancy to the territory from which their forebears were unjustly displaced. But suppose they're stateless. Right? Suppose they live in refugee camps, denied rights of, legal rights of free movement, legal rights for employment, they own nothing. Right? They live in huts over which they have no property rights, they have no legal right to work, and so on. Right? Do these people have a right of return. Again, scare quotes. They've never lived in the territory from which their forebears were displaced. Do they have a right of return to that territory? Stills says yes. I say that doesn't follow from the occupation principle. What does follow from the occupation principle is that the state that unjustly displaced their forebears, that is responsible, morally responsible, for their being in a situation in which they enjoy no stable legal residence in any territory, has a duty to see to it that they do get stable legal residence somewhere. But the occupation principle, nothing in the occupation principle implies that that stable legal residence must be in the place from which their forebears were displaced. Possibly in practice, that's going to be the only way to get these refugees stable legal residence somewhere. Right. Now, even if that were true, that would be a practical implication, not a matter of principle, as Stills suggests. But I don't think we should rush to assume that that's going to be true. Right? There are various ways in which these people could be granted stable legal residence somewhere. So for instance, state B in our scenario was the state that unjustly displaced their forebears. Well, state B may be willing to pay some third state, state C, a very poor state, which perhaps might welcome these refugees. Right? It might be able to pay state C to grant them stable legal residence in state C's territory. Right? Or perhaps a deal about trade could be made. Or perhaps state B could even give some territory for these refugees to establish, say, maybe even their own stable legal residence, though that territory need not be the territory that state B had seized from their forebears. And Stills makes an offhand remark that other states have at least a permission to pressure, as she puts it, state B, the unjust aggressor, right, to right the wrong it's done, even to the descendants of the displaced. Right? But it may be that it's going to be more effective for third-party states to, say, seize state B's assets abroad and use those assets to purchase stable legal residence in some other state for these stateless descendants of the displaced. So I think there are myriad possibilities here, and I think we need to be careful not to assume, first of all, that there's any principled right of return on the part of stateless descendants of the unjustly displaced. And second of all, not to assume that in practice, the only place we're going to be able to get them stable legal residence is in the territory from which their forebears were displaced. So far, I've been talking about rights of return on behalf of the descendants of the displaced, but in fact, I think some of these lessons extend even to those who were displaced themselves. Right? So remember that your claim to occupancy in a territory is premised on the fact that stable legal residence in that territory is essential, right, for you to live the life that you've planned, right, for you to form and act on a conception of the good. But it's possible that people who are unjustly displaced from one territory and then settle somewhere else, establish stable legal residence somewhere else, that over several decades, they may form life plans that are entirely premised on stable legal residence where they are now. And if that happens, then the occupation principle implies that they have a right of occupancy in that place and no right of occupancy in the place from which they were unjustly displaced. Now, in discussing the occupation principle, at one point Stills briefly mentions the case of Germans who were displaced from what is now Western Poland at the conclusion of the Second World War. And what she says is that their descendants have no right of return to the region from which their forebears were displaced. They have established stable legal residence. They have, in fact, all of their lives enjoyed stable legal residence in Germany. Right? Their life plans are premised on stable legal residence in that place. Right? And therefore, their right of occupancy is in the territory of Germany, not the territory that is now Western Poland. But I want to suggest that Stills, at least on the occupation principle, is actually committed to something even stronger, which is that within a few decades of their displacement from what is now Western Poland, those Germans who had once resided there no longer had any right of return to it. At least that's so if they have stable legal residence in Germany, right, and their life plans are premised on their continuing to have stable legal residence there. Right. There's something interesting about this last implication, already radical enough maybe in its own right, but something else that's interesting about it is that if the claim of those displaced from Western Poland, the Germans displaced from Western Poland at the end of the Second World War, if their right of occupancy in that territory had lapsed within a couple decades, then that opens the way for those who, culpably or not, set up residence in that territory. Right? The Poles who moved into those villages from which the Germans had been cleansed. Right? Let's not pretend this is anything other than what it is here, right? So this last point about how even someone who is unjustly displaced from a territory, he or she can cease to have a right to that territory, opens the way for those who did the unjust displacing, or who culpably took advantage of it, to establish a right of occupancy to that territory. Now that claim falls afoul of the no-fault condition that Stills attaches to the right of occupancy. Right, so you remember there are three necessary and it's a jointly sufficient statement of a right of occupancy. You have to be residing in the territory or have recently done so. Your life plans have to be premised on stable legal residence in that territory, and you cannot be at fault, right, no fault, for having formed that connection to that territory. I think we should reject the no-fault condition. Right? I think there's some initial intuitive attraction to it. It gets us two things, at least as Stills cashes it out, it gets us two things. First of all, those who unjustly displace people from a territory are barred from acquiring any rights of occupancy in it. And you might think that has to be the case, right? Otherwise, aren't we just saying might makes right? No, as I will show you. Right? The second thing, though, that Stills thinks we get from this is that the children of those who unjustly displaced people from a given territory, they can acquire rights of occupancy in that territory, because it's not their fault that they were born and raised in this territory and enjoyed stable legal residence in that territory. So importantly, on Stills' view, right, she thinks there's much more right of return than I do, implied by the occupation principle. Even if stateless people, right, descendants of the displaced, have a right of return and must be readmitted to Territory T, the children of those who unjustly displaced them, right, they also have a right to reside in Territory T. They need not vacate the territory. But I don't think fault has anything to do with it. So here's my first objection. Stills makes a kind of category mistake. Right? Moral fault or culpability makes no difference to whether a person successfully acquires a right to something, right, including a right to occupy a particular territory. Right? Culpability or moral fault here is relevant, I think, to judgments of praise and blame. I would argue that it is relevant to the justifiability of punishment and reward, although obviously there's some dispute about that. Perhaps it's even relevant to claims for compensation for harm done, at least in some cases. So in all those cases, right, I think culpability is relevant, but I don't think culpability is relevant to the acquisition or, well, perhaps to the loss of rights, but certainly not to the acquisition of rights. Right? So by way of illustration, suppose that I mistakenly but faultlessly take your jacket, believing that it's mine. Right? Now, if in fact my action was faultless, right, so not only was it not intentional, it was not negligent. Right? Well, in that case, we might think that I don't deserve any blame for this, even if in fact you've suffered some harm. Maybe I owe you compensation, maybe I don't. That's a tricky question. I'm going to assume that it would be wrong to punish me, though, even if in fact I do owe you some compensation. Right? But in no way does the fact that I faultlessly took your jacket generate on my part any right to it. However, suppose that you abandon your right to it. Not entirely clear in many contexts how you abandon it, but suppose you, from the tallest building on campus proclaim, I hereby abandon any claim to my jacket, right? Suppose that suffices. Well, what's interesting is in that context, I now can acquire a right in your jacket. Perhaps I don't even have to do anything. Perhaps my mere possession, right, will be enough to, at that instant, generate a right to your jacket. And I want to suggest to you that the same thing can occur in the case of occupancy rights. If occupancy rights lapse when a person's life plans are no longer premised on stable legal residence in a given territory, then when that occurs, right, the way is now open for others to acquire rights of occupancy in that territory, which they will do by residing in that territory and forming life plans premised on stable legal residence in that territory. So going back to the case of Western Poland in the decades after the Second World War, right, if we suppose that by, pick an arbitrary date for examples purposes, by 1970, right, that none of the Germans who were forcibly displaced from what is now Western Poland had life plans that were premised on stable legal residence in that territory, but instead enjoyed stable legal residence in Germany and had formed life plans that were premised on that fact, then their rights of occupancy in what is now Western Poland had lapsed. At that point, the people living in Western Poland, right, so they're residing there, assuming that their life plans were premised on stable legal residence there, at that point, they would acquire rights of occupancy in Western Poland. And in fact, they could do so even if they were the unjust actors who had displaced the Germans from that territory in the first place. Right. All right. Now, I think what distracts us sometimes in thinking about this, I'm going to argue that we're being distracted, you may disagree, right, is that we tend to think, right, that when a person acquires something via a morally faulty act, they don't subsequently acquire any right to it. But I think what's going on here is that we presume that the person who has a right to the thing continues to have that right. What I'm suggesting to you is that that may not happen. And when it doesn't happen, when the initial right holder's right lapses or is abandoned, right, then the person, right, then the way is open for someone else to acquire a right to it, including the person who did the unjust, right, act in the first place. 3 points I want to emphasize here. Right. It's not the unjust displacement itself which is generating any right to the territory. So we don't have might making right, although arguably we do have might, right, setting the stage for the possibility of right. Right. Rightful occupation does not depend upon rightful original acquisition. I highlight this because, well, there's many points of disagreement here with a Lockean account, but certainly this would be one of them, right? And finally, right, this claim about rightful occupation tells us nothing about the justifiability of punishment for the act of unjust displacement. So I don't want to rule out, I'm not ruling in either, but I don't want to rule out the possibility that unjust displacers might both acquire a right to occupy the territory in question and be liable to punishment for their initial act of unjustly displacing people from that territory. Let me see if I can wrap up in just a few minutes. Let me get one or two more controversial claims out here. Remember, Stills says that the non-culpable children of the unjust displacers, they do acquire occupancy rights in the territory because, again, they're not at fault for having constructed their life plans on the basis of stable legal residence there. Right? But I think that's a mistake as well. Right? If we assume, well, we have to assume a few things, but I think Stills at least would grant these. The first is if we think of the people who are displaced from the territory as continuing to have occupancy rights in it. So we're going to suppose that these people do not establish stable legal residence in the territory of some other state. And secondly, if we assume that they continue to constitute what Stills calls a political people, to whom she ascribes a right to political self-determination. Now, if it's part of the right of self-determination that a political people can exclude from its territory those it does not wish to grant entry to, at least it has a defeasible right to do so, then even the non-culpable children who are born in the territory in question cannot acquire a right of occupancy in it. They're not to blame for wrongly occupying the territory of someone else. That's true. That's the difference between them and their forebears, right? The unjust aggressors. But the fact that they're not at fault for that, right, doesn't change the fact that the political people that have occupancy rights in that territory and as a feature of their right to self-determination, a right to exclude others from that territory, right? The non-culpable children are in violation of those rights. Right? And so, if the original occupiers of the territory return to it, they would have a right to exclude from it, to cleanse from it, even the non-culpable children of those who had unjustly displaced them. Right? Now, it's defeasible, right? They cannot make them stateless. I could say more about how that would play out, but I think you get the gist. Okay. In sum, my arguments about the no-fault condition, I don't think fault is relevant in any way. Right? Instead, I propose that we replace the no-fault condition on the occupation principle with a no-rights violation principle. And you can see, I hope, on the basis of what I've been saying here, how that would work. All right. Where does this leave us? I've been working on this paper for about a year, kind of dipping into it for a couple of weeks, and then I get dragged off to something else. And one of the reasons why I think it was kind of lingering is because I didn't have an answer to that question. Right? I said, okay, this is a better version of the occupation principle. Stills has not properly worked out, right, the principle that she is proposing. But having, I think, worked it out properly, I was left with this question, okay, have I shown it then to be a good argument or a bad one? Is it a plausible account of what connects people to territory, and so states to territory? I'm still uncertain, but I'm beginning to get clearer on what sorts of considerations will factor into rendering a final judgment here. One is, have we got, in the kind of arguments I've been presenting to you for the last half hour or so, have we got a reductio ad absurdum, or a half dozen reductio ad absurdum arguments that show that we should reject the we should reject the occupation principle, right? What kinds of implications might provide the basis here? Well, I think it's all those implications that Stills tried to avoid, right? Things like the denial of a right of return even to stateless descendants of those displaced, unjustly displaced from a territory. Things like the possibility that the unjust aggressors may actually acquire a moral right to reside in the territory that they've seized, right? Maybe those constitute reductio ad absurdum arguments, but it's not obvious to me that they do. So for instance, it's not obvious to me that we're getting the wrong conclusions in the case of Western Poland. Right. A second kind of consideration that I think we should think about as we try to evaluate the occupation principle. Right. Is it enough that someone who was unjustly displaced from the territory they had rightfully occupied, is it enough that they have established stable legal residence elsewhere so that they are able to lead an adequate way of life? If so, then we have to say this. The fact that you're not leading the way of life you'd like to be leading, and that plausibly you would be leading had you or your forebears not been unjustly displaced, that fact is merely unfortunate, but not unjust. So that's how we come out on that question, I think, also is, should factor into whether we find the occupation principle plausible or not. So hopefully, by the end of this conversation, I'll have made up my mind. So thank you very much for your attention.
Okay, now we have Professor Priel for a brief comment.
Thank you, David. That was a very, very interesting paper and a very careful one. I have a few questions or comments or thoughts about it, but I admit that at least some of the questions that I had, you answered in your presentation. So
okay.
I think my comments will actually be a little bit shorter than I initially planned them to be. So if I understand, so there is a little bit, and you're completely open about this, that you read the paper with some sense, or at least I understood this to be a sort of friendly amendment of Annie's paper, but then you get to the end and then you kind of say, well, I'm actually not sure that all that I've done is right. And that sort of is something that I will follow. So first I'm going to ask some sort of internal questions and then raise some more doubts about the whole occupancy principle, which given your doubts about you may or may not accept. So if I understand, you have, depending on how you count, 3 or 4 problems with Annie's account. 2 belong to what you call the nature of occupancy, and there in particular, the fact that Stills insists on that the conditions for the right of occupancy be a claim to legal residence. And there, at least in the paper, and to some extent you clarified in your presentation, I wasn't sure whether you accepted the circularity problem or you didn't, and at least here you seem to have rejected it. But now I have something that I'm not sure about with regard to the way that your argument goes. So if indeed you then say, well, what actually is needed is not legal norms, but social norms, then why is the kind of emergent solution that you proposed necessary? Can't you just say, well, there are social norms that remain to exist, and that this is the foundation for the right of occupancy, and then you avoid the circularity problem simply by saying these legal norms are, the relevant norms in questions are social norms. On the other hand, I kind of tried to think why Stills went for legal norms, because the potential problem, at least of circularity, seems fairly obvious here, and a kind of mistake that you wouldn't expect her to make. And then I thought, well, perhaps she insisted on something like legal rights and not simply social norms, because what you get from ultimately is territorial jurisdiction, which is more than I think you can get from mere social norms, and that's something that I'm going to return to in the end. Social norms by themselves get some kind of community. They don't give a sort of legal relation of a state to a territory, which is what you want to get here. And that may answer your first question to me. So you do want to go for legal norms, and therefore not merely use the social norms which you use in the first place, because with social norms alone, you will not get to territorial jurisdiction. If, however, you say that, then you may have a problem with this, the problem of the second problem that you use within the nature of occupancy, the nature of the failed state problem, right? Because there you wanted to rely on the existence of social norms even when there aren't legal norms in place. So these are my kind of doubts or questions with regard to the nature of occupancy that you raised. Then the second area in which you have a problem with the account has to do with the right of return. And in particular, you say even if the displacement was wrongful, descendants and perhaps even non-descendants may not have a right to return if they've established a new right of occupancy in a different place. But in the scenario in which you have people developing residence right of occupancy in a new place, how does the acquisition of a right of occupancy in one place affect the right of occupancy in another? So it seems to be in the story, because it seems intuitive, that once you get right of occupancy in one place, the other one sort of automatically is turned off. But why should that be so? At least some people may want to say, yes, I have developed a right of occupancy, but that in itself should not kind of turn off my right to occupancy elsewhere. There is also an issue to which I'll return in a moment about the way in which you define the conditions that you define for what counts as right of occupancy. And I think you define them in two different ways. At some point you define them very, very minimalistically, which suggests that it's very easy to have the kind of social norms or the kind of scenario that's enough for the development of right of occupancy, which may suggest that there will never be a right of return. I'll return to this in a second. Okay, yeah, I have another point which I think you answered. Then the third type of problem that you raised was with regard to the no-fault condition for occupancy. And you say no fault, or sorry, fault is not a relevant condition because we may, even when someone comes into possession of someone else's property with no fault, they still have to return it. I have a little kind of lawyerly amendment to what you say there, which you say there that you never lose your property rights when someone else got your possession of your property, no matter how much time has passed. At least as far as the law goes, this is not always, I think, correct. You may say that may be a legal matter, but it's, at least as far as our moral understandings go, we never lose our property rights, no matter how much time has passed. Although I think you will know that some people, I think Arthur Ripstein, for example, from downtown, argues that the idea behind limitation of action acts, which are sort of relevant here, is substantive. It's not merely kind of a technical legal rule, but rather that you lose your right to property, perhaps if you don't kind of follow it up. But that's a kind of a little lawyerly aside. My two questions about it are as follows, about your claims. So you make a distinction there about between two cases, one in which the displaced people have acquired right of occupancy in a new place, and one in which they don't. And here's the point that I alluded to before, comes to the fore, which is, at least in your discussion in your example of Somalia, you say the conditions that you seem to require for acquiring a right of occupancy are very, very minimal. There you basically say, even though there's nothing there except for a few people living together and having some kind of life there, is enough for them to have the conditions, the social norms that are sufficient for, with the other conditions for the existence of right of occupancy. If that's the case, then you will never, almost never have a situation in which a displaced community, even if it lives in a refugee camp, does not have a right of occupancy in its new territory. And that might seem a little bit too harsh for them. So I'm just saying that there's that if you take seriously your claim about Somalia that you gave, you said, look, they do have something of a social system working there. Look, they still use the Somali currency. Then you will almost never have a scenario in which you say a group of dispossessed or displaced, people don't have not acquired a right of occupancy in their new location. There is a point that is in the paper that you didn't talk about, I think, which is you sort of say, well, there are moral principles and there's international law that can come and fix the problem that moral philosophy can, or that moral principles may get to us. In particular, you may say, you talk about the potential for displaced people the people within, to which a people has been displaced, kind of putting those who have been displaced in a bad situation exactly so that they would not have a right of occupancy in their new place, so that they could claim a right of return. I thought that was at least worth commenting on. So typically we would think that moral philosophy is indeterminate, and law can come and kind of fill in the blanks where morality does not get us there. But here you seem to suggest a somewhat different relationship between the two, which is morality is faulty, and international is needed to fix it. And I thought that maybe I'm seeing too much there in the way you see the relationship between the two, but I thought that's an interesting and perhaps unusual way of understanding the relationship between moral philosophy and law or international.
Right.
Now I want to go to the kind of more general points, and okay, and my specific points were fairly limited because I thought that as I said, you did a careful work in articulating what problems with Annie's account. So. One to which I alluded before, does this give us anything? Does this account, let's say we accept it, either revised or unrevised form, does this give us anything that's remotely similar to what we consider territorial jurisdiction in the kind of, now you may say no, but at least the motivation for this account, as I understood it, is to give us something that's fairly close to the concept of territorial jurisdiction as we fairly understand. Now, I still see a difficulty in understanding how you get from people living together and creating some sort of life plan in a particular plot of land to a state having territorial jurisdiction. Just to give one perhaps obvious example, although it may not be the whole story of why this is problematic, Canada has territorial jurisdiction over vast areas of land in which virtually no one lives. So what's the story about that? And that's probably not, and this I think is not the only, even in places where there is actual physical occupation, I'm not sure that merely the mere fact that people live together and have a life plan that is related to some plot of land is enough to create this territorial jurisdiction. Yes. Okay. Perhaps since I was told to stop, so I'll give one. I'll make just one more point. So central to your account, to your kind of amendment, is that, and I quote you, that displacement violates the property rights of the displaced by uprooting their entire lattice work of concrete legal rights that gives structure to their lives and informs their plans. This lattice work account, which I like this word, so I'll now, and I thought about this. You know, people move around a lot. Now, it's true that people move around a lot because they choose to. And that's a feature of kind of modern life. But what about someone who has to move because, you know, he or she is unemployed and they have to move half a country and kind of build their lives? So, so the idea that the problem with displacement is the uprooting of this entire latticework of concrete legal rights. I think at least most people who think about territorial jurisdiction and think about the problem with displacement think about something more than that, that it's not merely because, again, you can kind of go for crazy hypothetical. If you move an entire people from one place to another, their relationships to each other remain. It's just that instead of doing it in one city, they do it in another. Yes, they'll have to learn the new street and where the cafes are, but the kind of network that existed before will exist again. So I think that the kind of connection to land there is perhaps not what's really at heart. Okay, I have a few more issues, but I think I'll stop now. Perhaps if there's time, I'll ask you.
Okay, so perhaps you want to address some of these points. So we have an hour about now for your response and discussion. So I leave it up to you what you want to say about what was said, because there's a lot on the table, obviously.
Yeah, all right, let me just pick off one or two here then. Okay, let me just offer some quick responses. One thing that I think may speak to several of the comments that you made is occupancy is not supposed to give us the entirety of states' territorial rights, right? So Annie actually has 4 conditions that need to be met for a state to enjoy territorial jurisdiction. Occupancy is only one of them, but occupancy is going to be the one that attaches the state, which does all this, which has to meet these other conditions, to a particular territory. What else? Unoccupied territory. I think that's really a great question, and I'm not really quite sure what to say about it in this sense. On the one hand, I think we can tell plausible stories about how people's life plans may be premised on continued control over unoccupied territory. On the other hand, it strikes me that there's going to be plenty of cases in which it would be a real stretch to tell that story. And so does that entail then that there wouldn't necessarily be a wrong, or at least not this kind of wrong, involved in some other state's seizure, or group of people, stateless group of people seizure of that territory? Maybe there isn't a wrong there, and that might actually be okay. So while my general approach tends to be apologist, I tend to start with the world as it is and say, let me see if I can justify, it's not apologist or bust, right? Sometimes I say, well, some of this stuff actually has to go, and that might be one place. And if not, the story that we would tell about what goes wrong there would not reference occupancy rights. It'd have to reference something else, right? So the social norm view, I like your point about maybe that avoids the circularity problem. I have to think about that. But you also say, well, wouldn't that entail that even stateless refugees can acquire rights of occupancy in their refugee camps? Well, yes, and I would see that as a virtue, because then if somebody just comes and cleans them out of there, then there seems to me that there's a particular wrong that's done, and we would cash it out in exactly the kind of terms we've been talking about. So I actually think, again, that that's a virtue. Big fan of adverse possession. So I don't think any kind of, certainly not any kind of property right or right to control over a thing extends forever. But there are, as you know, people who do. So I would just take on the laws as
It's just
friendly.
In the paper you seem to suggest the opposite view that when you talk about the jacket.
Right. Yeah, or, but even if I were to say, I mean, the law typically is, I think, was going to require more passage of time than I seem to be suggesting in some of these most extreme cases. So there might still be some divergence between what the law would say and the position I was sketching out here. I've also been thinking about why does the acquisition of a right of occupancy in one place entail there's no right of occupancy elsewhere? I think it's because your life plans are premised on stable legal residence only in one place. And so now you might aspire to form plans that would be premised on stable legal residence elsewhere, right? But there's a difference between the actual life plans, the actual legal norms on the basis of which you're constructing your plans, and the legal norms and place of residence that you would like to be leading. Now, Annie says this at one point, because she notes this kind of thing, but I think she may be too quick, because I think there might be a difference. There's a difference between me saying, well, look, I aspire to be, a citizen of Jamaica, right? And since I aspire and I've formed all these plans about how my life would go in Jamaica, I have a right to live there. That seems misguided, right? That can't be enough to generate a right of occupancy. But on the other hand, if the only reason why I'm unable to realize my aspirations is because of someone else's unjust action, now that seems different. So, yeah. So, thank you.
Okay, so let's open it up to Professor Scaraffa. There are microphones too around the room. You need to speak into them. You can attach it if you want.
All right. Is it working now, or do I need to click a button or anything? Sounds like it's working. Yeah. Your feedback. So this is just a really basic question. So you want to connect you want to tell a story about right of state jurisdiction that's grounded in a right to occupancy. But one thing I was wondering, I was wondering if you need more than just a story about occupancy. Maybe you have to tell a story about this right to occupancy that's grounded in a particular way, ways that are maybe familiar from Walter's account of self-determination or the underlying value of self-determination. Because one thought you might have, particularly in the Windsor example, how different would the possibilities for autonomy be in Windsor? For living out their life plan as they want, as they'd like to live it, be if the U.S. annexed it. It seems like it'd be very, I mean, maybe that's a little sci-fi, that there wouldn't be too much, but you could sort of imagine something like that. Why does it matter who presides over these people's rights of occupancy? Because ultimately you want to talk about a particular state's right to its territory.
I'm not sure I follow, so let me say something and then you can say, that's not
Sure.
what I was talking about. So it seemed to me that you wanted to say, look, everything is not equal if the United States forcibly annexes Windsor, even if it's a legitimate state, even if it rules in a way that meets the conditions for legitimacy.
Well, I mean, things change,
Right.
but we're talking about, okay, what grounds Canada's right to territorial jurisdiction there, and if it's the right of occupancy of these people, if the people stay there and they still, get to, exist within their particular social orders and,
Right.
Live out their autonomous lives, what's the problem?
Right. Okay, so it's a different problem. So there are two kinds of problems, and they're often intermixed. One has to do with, I'm going to call it self-determination, although
Yeah.
the self-determination of the people of Windsor in this case may not mean they're an independent state. It may mean that they wish to remain part of Canada.
Yeah.
Right? That's one issue.
Yeah.
That's a relation of people to state.
Yeah.
There's a second issue, which is a relation of people to territory and state to territory.
Yeah.
Right? So I'm concerned with, I'm more concerned with the forcible displacement.
Well, there'd be no displacement in
Right.
this case.
Right. So,
But because I thought the point of all of this was to give an account of right to territory.
right. So I should have been more careful with my Windsor example. That's what price I pay for trying to be topical, right? I should have said that the people were displaced. And the reason that I would have wanted to tell that particular story is then it would highlight that it can't be their right to self-determination that's violated because they're still Canadians, right? So we can't, but if we still think that something's gone wrong here, well then it's going to have to be a story that connects people to place rather than people to state. So yeah, my mistake in the example, I think. Is that?
I should let other people.
But you might. But I mean, then do you want to? But then we need an account of political self-determination that would say why there's a problem here, even though people in Windsor. I mean, suppose we go the other route and the Canadians annex Detroit.
Yeah.
Having grown up there, I wish the Canadians had
Right,
annexed
right.
Detroit. Right.
Or the $5 million bridge, or whatever the bridge.
Yeah, that bridge. Well, thank you for paying for our bridge, by the way. Yeah, thank all of you. Right? It's Canadian taxpayers.
Well, actually, do you know that in the War of 1812, Tecumseh and the British occupied the area which is now Michigan and the city of Detroit. And based upon the laws at the time, all of Michigan should have been a territory of British North America.
Ah.
And it was only because the Duke of Wellington decided not to use the rights that Europe in that time, because Canada was British, and insists that Michigan, and especially Detroit, be a Canadian city. It really should have been. He gave the Americans a deal for some reason, I don't know, but
We were
in
this
fact,
close.
it should have been Canadian.
All right. Well.
We could have own M&M.
So right, so what we would want a story then that says why even if the annexation actually would lead to greater justice, let's say, nevertheless there would be something wrong here. But that's the story about self-determination, which I've also written on, but I want to try to stick to territory here. Right.
I have Michael Judy check. If you can pass the microphone down, please.
Is that on? So I I see, and I want to try and help about your question about the plausibility of the occupation principle, especially in ways which try and improve it and make up for some deficiencies in Stiltz's account of it. So I'm wondering then whether, in thinking about the occupation principle, whether it rules out certain kinds of life plans, and then maybe just get your thoughts on whether these are the sorts of life plans that ought to give way in light of the occupation principle, or whether certain kinds of life plans might be sufficiently important and meaningful for person's autonomy that it shows us that there might be something wrong, at least with the occupation principle, or we might need to work even further on modifications from Stiltz's account. So suppose it's part of someone's life plan, not just that they have stable residence on some particular territory, but rather that there are some particularities of particular territories which are especially important to their life plan. So these might be persons who are unjustly displaced. They might be the children of forebears who are unjustly displaced. So I don't want to pin too much on exactly which generation, but suppose it's part of their life plan that for their lives to be meaningful and to have the kinds of relationships and identities that they think are important or are important to them, they have to be living in a particular territory which might have some special historical significance to them. So it might be the site of a historical event, which is very important for the identity of a certain group of people, which forms attachments which they just can't shake those from their life plan, right? So there might have been some particular war, conflict, or struggle which took place on a particular hill or in a particular valley, and that particular place, not just a valley or a hill, but that particular one on the earth is especially important to them, to their identities and meanings. Does the occupation principle rule out that kind of life plan? Like, is it going to say, well, no, you ought to be able to take up residence in any stable environment, or is there room for that kind of
Right.
plan?
Good, thank you. So David Miller gives an account of nations' connections to territory. And so individual connections to territory are mediated via membership in the nation, in which it's grounded partly in a kind of quasi-Lockean generation of material value from the place, but then secondly in what he refers to as symbolic value. And he gives examples of symbolic value that is sort of thing that you're mentioning. So a historic battlefield or a sacred mountain or this sort of thing. Right? And he wants to use that to ground a territorial claim that can extend multiple generations after displacement. Although interestingly, even for Miller, it does seem to lapse at some point. Here are my thoughts about the symbolic value arguments. They seem sufficient to me to generate rights of access. Right? And when you think about one kind of proposal that has often been put forward regarding the governance of Jerusalem, right? I'm thinking of a kind of proposal that has emphasized this idea of right of access to holy places in that city. So if it's very important for a way of life that on a given date every year, people be able to make pilgrimage to a particular place, that seems to me to be strong grounds for at least a pro tanto right of access to that territory. But I don't see how you can get all the way from that to a right of residence in that territory. But I like that you suggest something more than just it be important to go to a particular place on a certain date, but that somehow it be essential that you live, as it is often said, in the land of your fathers type thing. I feel some of the pull of that kind of claim. So, I don't feel it personally, but I can see the force of that, and that's, I think, one source of hesitation on my part to endorse the occupation principle. I'm not I'm uncomfortable kind of, maybe as you were inviting me to, kind of just dismiss it out of hand and say, tough luck. As I said to Dan, I think there's a difference between maybe you've just formed some aspiration to be able to live, I'd love to live in Hawaii, doesn't mean I've got a right to, type thing. But again, it seems to be different if there's a plausible counterfactual that suggests that you would be living there were it not for some past injustice. So I think I can handle certain kinds of arguments of the sort, but I'm not sure I can handle all versions to my own satisfaction.
So I have myself, and then we'll move on to Bob and Stephanie. Joseph has this example, right, where there's an accident on the highway, and the doctor arrives on the scene, and he's the only one that can basically orchestrate the salvage operation, and because of his knowledge, and he actually is somebody that people will listen to, right? So he has de facto authority. So he says, well, that's one example where there's an individual here who has practical authority over a situation. Now, it seems to me that you want to say that's not enough for the state to have the right to rule, to be that kind of necessary institution to discharge certain facts, certain important things such as justice. We could follow Stefan's suggestion and say, well, you can add a bit of a self-determination part of this to the story. You seem to say, well, that's not where I want to go. I want to add another condition to this, and that's the territorial condition, right? We need to be able to account for this in order to account for the state to have the right to rule, right? You say, it's your first sentence, right? Modern states assert a right to rule not only over particular people, but over particular territory, right? So I'm wondering, what is the role that territory really plays in your account of authority? Is it this, a kind of limitative condition that we add at the end of the kind of analysis that I suggested, or is it something else? Is it actually an expansive condition when we say, well, actually, this state has a right to rule over this territory, and even in cases where you might not have the right to rule over certain people because it doesn't enhance, for example, justice in their case or whatever, if we apply something like the normal justification thesis, is it an alternative? As it were, because an appeal, what I find appealing about a story like Joseph Rath's story, the normal justification thesis, is this piecemeal condition, right? Is that we assess the authority vis-a-vis every single individual in various situations. The state can have authority over certain individuals and not have it over others. I'm talking of legitimate authority, obviously, over certain matters and not others. So what does territory does? So that's the first, that's the first point. The second point is, well, what territory, right? We've talked about part of Poland. We talked about certain parts of Canada. And one example that came to mind is Western Sahara. Right? Western Sahara, you have people who stay there in Western Sahara, in the south of Morocco, let's say, right? And they're Moroccans, right, of the Arabic lineage. But you also have the nomads who actually don't stay there, right? But claim actually that they have much more of a right to that part than the people who actually stay there, and probably have much more of a capacious right to occupancy than the nomads would have. Mm-hmm. Right? So how does that kind of territory fall within your account? And the other point is the point you suggested at the end, which I think is a very powerful one, right? If I'm a resident of one country and I'm displaced to another country and I'm given barely adequate life options, right, to craft my life plans. And I look back and I say, my God, what I had in my country was so much more wonderful. And what I could have if I went back there would be so much more wonderful. What do we do with this kind of qualitative difference, right? The threshold approach that you and still seem to be adopting when defining your right to occupancy seems to me to be very, very brash, right? And even then we could think about one individual out of the group saying, it's so much better for me, but the others saying no, or most of them saying, much better for us, but some of them saying no. What about, do they have a right of return that others don't have? So, yeah.
Right, good. So, lots to say. The first is, take the very last point. I think there's going to be a fair amount of indeterminacy here. So if you were talking about the groups,
right,
and you say, well, what about if the conditions are met for some but not others? I'm reductivist here. Right? I don't think there's some kind of summation then to the group. I think that it's just, if you wanted to speak of the group, you'd have to say it's indeterminate whether the group has.
So individuals, right?
But then there's going to be indeterminacy for individuals, because surely there's going to be some point at which you've got 1 foot in your old life and you've got 1 foot in your new life, right? And what to say. I think it's genuinely indeterminate, not just that we don't know, but that there's nothing more to say than you've got 1 foot here and 1 foot there. And as Dan suggested earlier, it's cases like these where it's one instance where we might need law, because we're going to have an answer about whether you get to return, you have a right of return or not, right? So that's the first thing. The second thing is Western Sahara. Occupancy is not the same thing as territorial jurisdiction. And the reason why we're going to have to add more to occupancy is precisely because we're going to have disputes about exactly what you get to occupy, right? So I think we need to be able to add some content to what it is to occupy a place. You know, what's the place that you occupy? But that content is going to be highly indeterminate. And it's exactly, again, here comes the law, right? Because it's going to be indeterminate that we need to settle that. As a matter of history, nomads have consistently gotten the short end of the stick in the particular legal resolutions that have been reached, but I don't think those legal resolutions were the only ones that could have been reached. Whether they were the most just or not, I'm not prepared to say, but I certainly don't think they're the only alternatives we could have adopted. RAS and territory. All right, so first on territory. We need this account of territory because even if we assume a kind of Rawlsian account of legitimate authority over people, if one state one day annexes the territory of another, right, whether or not it displaces the people, that strikes me as problematic, that from that very moment it enjoys a right to rule over that territory. It may be doubly problematic if there's an issue both of self-determination and violation of territory. It may only be singly problematic in the case of territory, right, if there's displacement of those people, right? But still, my intuition is that that's problematic. But not everyone's going to have that intuition, in which case it's not a problem. I can't resist, though, the chance to say something about RAS. The piecemeal nature of practical authority on Ras's account follows not from the normal justification thesis, but from his account of the reasons that apply to us independently of law. I disagree with him about what those reasons involve. So I think that in circumstances of reasonable disagreement over what morality requires, but in which, in order to treat one another justly, we need to have, for action guiding purposes, answers to these questions, we have a reason to submit to a common authority. And that's not going to generate a piecemeal account of the authority of law. But that's not the normal justification thesis. That's a dispute between Raz and me about the nature of reasons. Right. So.
Bob Myers.
Yeah, this may not add too much that's new, but I had sort of both one of Danny's questions and one of mine. So I also was a bit puzzled why you seemed resistant to the idea that one might just have a right to occupancy in two places, both the new home and the old land. And in part for the kind of reason that Mike was suggesting, that my life plan might be, in some sense, sort of multi-track like that. I've got these plans. I plan to make the best of it in the new land as long as I'm not allowed to go back to the old, but for various reasons I would maybe like to go back to the old if I could. So, I mean, if you treat the life plans purely subjectively, it looks like that's clearly, people could have plans of that sort. So what you seem to be saying in response, you seem to be applying other filters of a kind, right? There are reasons why those life plans are unreasonable or not to be given the same kind of weight here. And so that just, I guess a methodological matter, gets me wondering, well, if we build too many of the answers that we want into our conception of what counts as a reasonable life plan up front, then maybe it's not circularity exactly, but maybe there's not quite as much payoff.
Right.
Here. We're not getting quite the kind of analysis of the right to occupancy in terms of life plans and so forth as we saw.
Right. So, thank you. Okay. I use life plans because it's a lot shorter than saying the integrity of the structure of goals, pursuits, and relationships that constitute the conception of the good life. But suppose that we actually use the full characterization that Stills gives us. For those who have been displaced from some territory, or for those whose forebears were displaced from that territory, if you actually examine, right, their goals, pursuits, their relationships, and so on, right, the vast, vast majority of those are premised on stable legal residence where they are, right? If they enjoy property rights in this territory, but not in that one, right, on the plausible assumption that almost everything that you're planning involves the use of property or takes into account others' property rights that live in proximity to you and so on, that's the sense in which your life plans are premised on stable legal residence where you are, and not premised on stable legal residence elsewhere. Now, just for clarification, though, I don't think you were saying this. Obviously, if you are a citizen of two countries or have some legal status in both and spend half the year, blah, blah, that's a different sort of thing. But if we characterize, as I was just characterizing, maybe a little more carefully, what the conditions are that need to be met in order for you to have a right of occupancy in one place, then maybe that makes the difference between your connection to this place and your connection to the place from which your forebears were unjustly displaced a little starker. And maybe then that gets to why you wouldn't have a right of occupancy in the old place.
No, I think that would be good. I think that's the kind of work you would want to do, because you certainly don't want people to have the suspicion that, well, it's partly because you want ultimately to ground the right to jurisdiction, not fully ground, but sort of partially grounded in the right to occupancy. And obviously jurisdiction, you don't want that to be multiple or contested. So you wouldn't want, again, the fact that that's your goal to sort of make people think, well, maybe you're trying to get there by. Okay, thanks.
Right. But let me add one more thing too. I think there's a tendency to characterize, and maybe we do this with property rights. You do some act at some time and you acquire the right in that thing. And it's almost as if in virtue of having done that act then, that's enough for that right to persist. Maybe not forever, but persists. And nothing else need be happening between you and the object in order to sustain the right. I mean, I bought that candy bar and I don't have to do anything else. And that candy bar is mine, right? But I don't even know whether that's true of property rights. But even suppose that it is, occupancy right is not working that way. Right. The occupancy right is emergent from a state of affairs. And as that state of affairs is realized or not, every time, that determines whether you have it, not whether you had it at one point and then somehow that generates a continuing right, come what may, for a while. Yeah.
Stephanie Silverman, microphone.
Thanks. We have a pretty active corner over here. I don't know what's happening, but
Especially since the next person is also from your corner, but yes.
well, maybe to make the mic travel easily, I think.
For your question.
Yeah, so thank you. That was really interesting. And I was with you for the most part. I just have a couple concerns about the expelling of the children of the occupiers, because that seems to me incredibly morally problematic. And I hope you'll forgive me if I mischaracterize your position and Annie's position, because I don't have it straight in my mind where you overlap with her and where you digress. But if I could just say my couple quick issues with that. And so the first one is that in your oral presentation, you said that if the stateless people return and they're a political people, then they regain control and they have the right to exclude people from territory in their quest for self-determination and by virtue of their territorial jurisdiction. Okay. But I think that exclusion of someone at the border is different from expelling versus mass expulsion, especially given that the children had no choice in where they were born.
Right.
So, I mean, that's like extreme coercion over something that someone did not consent to,
Right.
and that they've already built their whole life over.
Right.
And the moral difference between saying, no, you can't enter and pursue your life here, versus saying, I'm going to uproot you as a matter of maybe reparative justice and intergenerational justice, doesn't seem to connect with me.
Okay.
So I would I would wonder what you would have to say about that, and it's possible that, again, that I mischaracterized that. And just to push it a little bit further, I mean, what about if we could say like that there's a reverse in children who occupy? So I'm thinking here of children who are brought into a state against their will or not being able to give full consent because they are not adults. They're 5, 8 years old, so they have to go where they're taken. And then they build a life for themselves, they contribute to society, and then they ask for the right of occupancy and they ask for the right of citizenship. And so we can point to the Dreamers movement in the United States as being the most well-organized vocal group. Do you think that there's any sort of reverse parallel or kind of implication of the argument there? Because it would be that those children also don't have that. By the same logic, I would see that those children would not then gain the right of occupancy, implying citizenship in the place where they've grown up.
Right. Okay, good. Thank you. All right, so first thing is that you aptly described what I think follows from the occupation principle, not what Annie does. Okay. Right? But I don't think she's given us, and you offer actually, I think, a slightly different justification for the conclusion she wants to reach than she does. So she hinges it all on the absence of fault, right? You add that as a condition, but then you want to build in some other forward-looking considerations, I think. Be that as it may, let me see if I can defend my account here of what follows from the occupation principle. First thing, I concede that there's a moral difference between blocking access to the territory and expelling someone from it, and expelling is typically going to be much more disruptive to somebody's life than blocking them. Maybe not typically, generally at least, right? I think that would be true. But think of Tibet, right? And suppose that is a slight exaggeration of what has actually occurred, that China had much more ruthlessly ethnically cleansed Tibet when it seized control of it in the 1950s, right? And then suppose also counterfactually that, this is not counterfactually, that China repopulates the Tibetan region with lots of Han Chinese, right, who bring with them an entire culture, right? Not just a political culture, but right, religious culture and a social culture and so on. It's very, very different from the Tibetans. Now suppose that, this is counterfactual, China was compelled to readmit the Tibetans and withdraw its rule from Tibet. Okay? The likelihood of the Tibetans being able to sustain their culture, right, their way of life, if they also have to grant full and equal citizenship, right, to large numbers of Han Chinese who non-culpably moved to Tibet, seems extremely unlikely, right? Now you might say, too bad, that's unfortunate for the Tibetans, right? But if not, if you want to say, the Tibetans, they were treated unjustly, they have a right to this territory, that's occupancy. They have a right to control over entry into it for the purposes, amongst other things, of sustaining their culture, right? Then that entails that they've got a right to expel even the non-culpable Han Chinese who have populated that region. Now, do the Han Chinese, non-culpable Han Chinese who are there, who are expelled, suffer a wrong? I'm actually inclined to say that they do, but not at the hands, right, of the Tibetans, but rather at the hands of whoever it is, right, their parents, let's say, who culpably displaced the Tibetans and brought their children to Tibet in the first place. So by analogy, I think that if you have the conviction of a thief who is in fact really guilty, not just found guilty, right? When she's sent to prison, I think that causes severe disruption to the lives of her children, right? But all else equal, I don't think the state is wronging the children by imprisoning the mother. And it's that kind of story I would want to tell here also.
Joanna Langer.
Thanks so much for such an interesting paper. I think I'm going to really very much follow along the comments that this team has been making today. I want to push you more on the relationship between the occupancy principle and individual private property rights or private rights in general. So I want to know how your account deals with the loss of private property of displaced peoples, because what I see in this occupancy principle is a focus on things like, as you say, life plans, relationships, belonging, potentially self-determination. But all of these are fungible in that, as you say, one can pick up, move these communities, and potentially reconstitute them elsewhere. But when a people is displaced or annexed, there's also a complete and absolute loss of private property by those individuals. And I don't see that accounted for at this point in the account. And I wonder if this might be a way, by focusing on the private property loss of individuals in the occupation context, you might get a little bit closer to why the state has territorial authority. And also, you might be able to understand, if you look at it in this juridical lens of private property, why the passage of time is so meaningful, and why the complete collapse of a state authority, which makes the possible re-rendering of these private rights, potentially possible in the future, a plausible alternative. So I guess, I hope that makes sense, and it really does build upon what we see in prior questions.
I'm not sure I follow. So, no, it's not. You suggest, you're asking where's private property in all this? I mean, why can't we say that people have a right of return because they've got property rights there, and restitution of property requires.
I'm displaced
Right.
from my home.
Right.
My home is full of beautiful art that I've collected.
Right.
I may be able to reconstitute my private relationships with my son, my daughter, my husband, my community, my life plans elsewhere, but I've still lost my house and my paintings, and
Right.
they're still sitting there in Windsor,
Right.
annexed by those terrible Americans.
Right.
So I want to know, even if I'm able to rebuild my life elsewhere,
Yeah.
the account offers me no compensation for
Right.
the loss of my private
Good.
property.
Right.
And I think that maybe by focusing on that lens, and I think actually if you look, I don't know why Annie doesn't go back to Kant's text on this. This is how he, I think, understands when a state is fully dissolved, when there's no possibility of possessing property rights. That might be is that more helpful? Sorry.
Yeah, so two things. One is, Annie says, even if you don't have a right of return, you would still have a claim to compensation for harms suffered, such as deprivation of property, right? But notice she doesn't say restitution. She doesn't say you get to come back to your house. But she does say you should get some kind of financial compensation for the loss of your house, right? I actually am concerned about how exactly that's all supposed to play out. This strikes me actually as a very uneasy kind of trying to have your cake and eat it too. But suppose we grant that. Would that be enough to say, or do you want something more than just, hey, you should have also said something about compensation for the property they lost?
So
or do you want something more than that?
I'm not saying actually that there needs to be compensation. I don't. So I guess that Kant would say that once your property rights have been destroyed and
Right.
there's no more legal authority capable of giving you those property rights. So let's say that the territory descends into a state of war and
Right.
you can't claim compensation and you've just lost them. And
Right.
tough luck for you. So I'm not saying you have to build it in at all, but I'm just saying that to me it is a more plausible theory of why invading so there seems to me to be a public component of why invading a state is wrong and a private component. And that private component goes a long way in explaining why states have territorial authority. And so I'm clearly not being fair.
No.
Sorry.
All right, so property legitimacy, the exercise of legitimate rule, is, most importantly, Annie thinks, to specify property rights, to make determinate what are provisional property rights, is going to be a necessary condition for a state's claim to territorial jurisdiction. Right? So if it were possible, I'm not even sure this is possible, but if it were possible for there to be a state which somehow then didn't carry out that function, it would not have legitimate, it would not have territorial jurisdiction, right? But suppose that it's only Windsor that is annexed and its people displaced into the rest of Canada. I mean, there's still a state there, which is the kind of entity that could enforce property claims, right? So, I'm not sure this is what you're saying.
Wouldn't that be a good argument for me getting my house back in Windsor? The American government is still there. I own the deed, the title to the house. It was taken from me wrongly. It's in a legal system that is recognized by my legal system. And you would say that, and even if my parent gives the mother gives the deed to her child, you say that that child loses title by virtue of someone else, the next child having the occupier continue.
Yeah, so, but then this is my concern, is that if Canada is not actually exercising jurisdiction over that territory, then that deed doesn't mean anything.
But that's what I think you need to account for, is that how is that the private right suddenly stops meaning anything?
Oh, well, I think they only mean something if if there is at least a state, if not a legitimate state, that's actually enforcing law over that territory. Otherwise, I mean, why can't we just start handing out deeds to territory all over the world and saying, we claim jurisdiction over that. We don't exercise it, but we're going to assert jurisdiction over it. Here's a deed. You own Maui, right? But surely that's not going to generate any kind of claim to Maui.
Any further question? If not, I'm just going to pass the microphone back to Dan.
So one of the thoughts that kind of occurred to me through the discussion that, so there, I think there are three types of scenario that you're talking about here, and perhaps, and I admit to being unfair because I'm kind of throwing it at you, and I don't have an clear answer to it myself. That there are three that perhaps you're trying to do too much, and perhaps that affects. So one is the displacement case. One is the failed state case, and the third is sort of what Stefan talked about, and sort of you with the example of Windsor, and I actually have a real life example of it that's not fanciful or crazy. So in the talks that, of course, nothing will ever happen between Israel and Palestine about what will happen there. So one of the suggestions is that part of a solution is that some villages that are mostly occupied by Arabs, by Muslims, that are currently part of Israel proper, after when kind of resolution is reached, the border will be redrawn so that they become part of Palestine. The people are not moved in any way. They keep their houses, they keep everything in them, they keep their whatever social norms that exist in the town, but their passport changes. There's great opposition to this. And so now it's not, so it's true that it's not exactly the sort of issue that you're talking about, because there's nothing, well, perhaps it is, because there is a case in which two states kind of agree on something, and the people who reside say, no, we don't want that, and who are you to decide this for us? And so I thought, and that's kind of what I'm throwing at you, that you may need to be, if you're ultimately convinced that this account works, which I know you may not be, that they need to be treated differently or thought about differently. And one kind of, to connect this to an issue that we talked about before, is the fact that, so in the case of the redrawing of the border in the same way of the Windsor case, as Stefan said, the issue of the loss of the lattice work seems not to be the case, and so it may therefore require some other sort of, it may not work in the same way that the displacement case that
right.
you. Then another kind of tiny thing. Does not this account give incentives to state that kind of took displaced people to treat them badly? Because that will, because then they will not have a right of occupancy in their new place,
right.
and this thereby be have a stronger claim to go back on the assumption that those states don't want them.
Right.
And again, from Israeli-Palestinian conflict provides wealth of
Yes.
examples about everything. So refugees who live in Lebanon, in Syria, etc., many of them don't have citizenships. They're barred from certain occupations. I don't know, and that goes back to my question before, whether this counts as right of occupancy or not. They
Right.
live. They're second-class citizens without a doubt, but on the other hand, they do have the, I suppose, the kind of network of and life plan that is, and so that's and perhaps one reason why Lebanon, Syria, etc. Treat those refugees as second-class citizens is because they think if we integrated them, they will become our citizens, and we don't want them. So actually, it gives them a sort of incentive to treat them bad.
Yeah, even, and in fact, I think it's a lot like the Tibet example that I was giving. I mean, were Jordan to grant citizenship to the Palestinians living in its territory, it'd be the end of the Hashemite rule, right? So, yes. Let me just talk the first question, because that'll only take a second. Self-determination and displacement should be treated separately, right? And I haven't really tried to say anything about the self-determination issues today, but I find I have to work at it to make sure I'm not falling into an issue of self-determination when I really am just concerned with displacement. Yeah, all right, so you said something earlier about this part in my paper that I did not mention in the talk, which is a concern about the moral hazard of rights supersession. Right? And my solution to the moral hazard problem was, well, maybe international law would deviate, or should deviate, from what morality truly requires. So international law would assert a right of return beyond the actually morally justified right of return. Right? I didn't think that was a fault with morality, but I did think it was a fault with people. Right? So moral hazards in general are not indications of the shortcomings of justice. They're indications of the shortcoming of people who will be encouraged to act unjustly by certain principles of justice. Right? And yes, I think that this is exactly what happens in the case of refugees, that they get perhaps worse treatment than they otherwise would. And that it might then behoove us to try to design international law in ways that would reduce that.
Okay, on this note, I will ask you to join me in thanking Professor Lefkowitz and Professor Priel. Very thought-provoking presentation and response. Thank you very much.
Thank you.